Hey guys, and welcome to the weekly docket. Hey guys, good morning. Let's get this slideshow up here. Got the comments rolling. Talking about Megan a little bit in the chat, but she's toward the end of this, so we'll come back to it. All right, so let's talk about Daryl Brooks first. What he's up to with Erica Patterson. I'll be very careful here. I did accidentally call her Erica Brooks at the beginning of the other broadcast and was blasted for that many times, and that's fine because I regret making that error. All right, so the trial date was vacated due to this motion to withdraw. So there is no trial date right now on the docket. The motion to withdraw will be heard on the 14th of August. That's when the trial was scheduled to occur. And it is right now on the docket of Judge Michael Hanrahan. So it goes off of Judge Havas now to Judge Michael Hanrahan. Don't know why. It doesn't really make any difference, but that's what will happen. We'll see if that streams on the 14th of August. That will be interesting. I haven't seen the motion to withdraw, and it may indicate what's going on, but likely I would concur with everybody's supposition that this is his moment to go pro se, profane again. And listed here in the slide are the charges he's facing in that case. All right. You know what else to say about him on that one. And to repeat again, his appeal, the transcript was extended to November 18th, 2023 for delivery. Maybe it'll actually be ready by then, or perhaps so at that point. It's been quite a while, but whatever. They can take as long as they want on it. It doesn't bother me. Now let's go to Bryan Kohberger, which case is a little more complicated and some interesting developments in that. And before I get into it, I certainly don't say he should be voted as guilty at this point, because we don't know all the state's evidence, and we don't know what the defense will say about that evidence, and we don't know then also what evidence the defense will have. So who can really say for sure? But I also would say that if the position is they have zero evidence against him, that's a very weak position. At any rate, here comes dismiss the indictment. Now, there are two things filed, and one is under seal and has to do with how the grand jurors were selected. But let's look at the quality of this argument for dismissing this indictment. And here they're saying, well, Judge, either throw the case out or just send it back to a preliminary hearing. So that wouldn't result in the case being discharged. And even if it were, you'd probably see another, indictment filed, and then it'd be a fight over that. But we were told about the conspiracy, you know, the planted evidence, and not that the defense ran so far with that, but, you know, you hear that on social media, and the prosecution misleading everybody. Well, let's look at how they misled this grand jury. The issue that the defense raises here is saying that the grand jury was misled. You can see down there at the bottom, paragraph 2 for the issues. The failure to properly instruct the grand jury as to the standard of proof. That's grounds for dismissal of the indictment, and that does sound good. But look at the first paragraph. They are saying that the grand jury should be instructed that the standard of proof for the grand jury is beyond a reasonable doubt. Who's buying that so far? All right. Whatever. Okay. Now, let's talk about who's not buying it. In the defense's own brief, here's this paragraph that occurs a few pages into it, because, you know, you get the sound bites based on misleading the grand jury and stuff, but it's based on saying the grand jury should have been told they have to find proof beyond a reasonable doubt. And at the bottom is the actual rule in Idaho, the real rule. I didn't write this, the thing in yellow, this is the rule. If the grand jury finds after evidence has been presented to it that an offense has been committed, clearly one was, or 4 were, and that there is probable cause to believe the accused committed it, the jury ought to find an indictment. And that's what the jury was told. So I don't think you're really misleading the grand jury when you are telling them what's in the rules. But anyway, look at what the defense said. That said, the defense recognizes that the whole of modern jurisprudence on this issue is against it. Does the defense say, look at these exceptions to modern jurisprudence or anything? No, they don't, because the typical standard for a grand jury is probable cause. And that's what the Idaho standard is. That's what the cases are. So they filed this document, they signed it, it's all in good faith or whatever, but this is bordering on something not good. So if you're taking everything that gets filed in court as having a serious basis behind it, Keep in mind the defense here says for this motion, for the grand jury being misled, that the whole of modern jurisprudence on this issue is against it. So, okay. All right. Now, again, there is another thing on the record, but it's under seal. It has to do with how the grand jurors were selected. Maybe a technical defect that's being alleged there. I haven't seen anything that has to do with anything that's actually real or material. So there's been a lot of smoke about, how the grand jury was wrong or whatever, but that's the first argument on the public record. And I probably wouldn't have filed that one. You do want to retain some credibility, right? But this is a good judge, and he maybe can laugh off that one and still take seriously whatever else is said. But it doesn't look like the indictment is faulty under the grand jury as we presently see it, although they are asking for more time to research this carefully. All right. So let's see. Okay, let me get off of this, dismiss the indictment, because again, I've said it twice, and I don't want to say it a third time, but I will. The defense recognizes that the whole of modern jurisprudence on this issue is against it. So no. Now let's talk about the alibi defense. Here's the statute. Again, not imagination or somebody's opinion on social media or whatever. This is the operative statute. Let me see if I can read it here. That the defense has to provide a written notice of his intention to offer a defensive alibi, and the notice shall state the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the name and addresses of witnesses upon which he intends to rely. You see that? It doesn't say, well, just tell us you have an alibi, but you don't really have to say anything about it. The statute requires that you state the specific place or places that you say you were at that time and who's going to support you on it. So now his alibi could have just said, I was at home and I will support that. And I believe an expert witness, so-and-so's name, why don't you have one, will say that I was there as well based on my telephone evidence. You could say that because you don't have to have an alibi to be innocent or not guilty. And if you live by yourself and a crime occurs, say, between 2 and 5 in the morning, and you weren't the one committing the crime, you might just be at home asleep. And other than your phone being there near you, who would be a witness for you there? So the fact that he doesn't really have an alibi, as we see as of yet, that doesn't mean that he's guilty or that it's bad for his case. But it also doesn't mean that this isn't ridiculous, what is going on right now. So the statute requires the submission of the alibi. Tell us where you say you were then. You know that. You know where you say you were during that time. Why do you need us to tell you that? That's the statute. Now let's look at what's going on here. So here's what the defense said. The defense team continues investigating and preparing his case. That's good. Evidence corroborating his being at a location other than the King Road address will be disclosed pursuant to discovery and evidentiary rules as well as statutory requirements. Now, it's anticipated this evidence may be offered by way of cross-examination of witnesses. Okay. So in other words, we don't have witnesses for this. We'll try and get it out of your witnesses, and as well as by calling expert witnesses. So what is the alibi? You said you had an alibi, and I guess you don't have an expert yet that's going to prove that for you, so you can't name them. And you also aren't even saying where he was. Now, remember, the statute says you need to say the specific place that you claim you were and who's going to support it. Now, your failure to do that can result in that evidence being excluded from the case. You can't bring up an alibi in the middle of trial in a lot of states, and the Supreme Court supports that. So we'll go over that here in a second. So now the state has responded to that. I mean, this is all just a flurry of documents in the last couple of days. And they say that the defense needs to tell us the specific place or places at which the defendant claims to have been at the time of the burglary and homicides, and the name and addresses of the witnesses who would support that. And they say, of course, he has a right at this point not to talk, but if he wants to rely on alibi, he has to declare these things. And as you saw earlier, that's exactly what the statute says. It doesn't say you can give a notice and just wait until trial, see how it works out. That is, the penalty for that is potentially having your alibi excuse excluded from trial. Bradley Yon tried to come in with that and say, my father is going to say that I was with him that night, and the state objected on the basis of no prior notice of alibi, but of course his father didn't end up saying that anyway. So let's see what the state says in its brief. Similar to the situation in Juarez, which is another case, the state has no idea how the defendant's notice regarding alibi constitutes an alibi. because it doesn't constitute an alibi. They don't say in there he was at home asleep, or he was at this bar, or he was with his family, or he was camping with his friends. They don't say the specific place that he was not at the crime. And that's what an alibi is. And that's what the statute requires you to say. So the state is unable to comply with its obligations because once the alibi notice occurs, the state is then supposed to provide information of how they intend to rebut that. Well, how can you rebut it when you haven't been told what it is? We don't know how this is an alibi at all, and also quoting a case for that. They also quote a little court called the United States Supreme Court in Taylor versus Illinois, which says the ease with which an alibi can be fabricated and the state's interest in protecting itself against an 11th hour defense is both obvious and legitimate. The adversary system of trial is hardly an end in itself. It is not a poker game, which players enjoy an absolute right to conceal their cards until played. So if you did have an alibi, then you got to tell it under this. So that's pretty simple. So as I said, by statute and case law, failure to provide the alibi details as required can result in forfeiting the ability to raise alibi at trial, except the defendant can still testify. But that's only a risk, all right, if you actually have an alibi and you're trying to hide it, rather than you're just trying to create the impression that there's an alibi when there's not. Because, you want to have momentum on your side. You want to preserve your options. So you throw this out there kind of like the grand jury being misled, and you saw what was actually said deep in the legal filings on that. So there will be people who tell you what you want to hear on this, either to the guilt side or to the not guilt side. But I think it's important to look at the actual filings themselves and see what is really going on here. Again, the lack of an alibi by Kohberger to me does not say he's guilty. Now, it would point to innocence if it existed, but if you're a single guy and a crime occurs in the middle of the night, it might be hard to have a real alibi other than your phone being there. And of course, you could have left your phone there and gone and done the crime. So that's tough. And I'm not saying he has an obligation to have that for somebody to think the state is not going to be able to prove its case. Because I can respect the position that people say, look, I'm not ready to swallow all this yet against this guy. I think there are issues with this, either in I need to know more about this DNA and how they're going to show he really put it there. I need to understand more about how come the car doesn't have evidence on it. I respect all of that, but there is evidence against the guy. Whether you think it's compelling or not could be a different story. The I'll tell you later when I cross your witnesses, I didn't see that in this statute as an exception to having to provide the alibi. I mean, just say he was at home. If that's what you think he's going to say, he's your client. He knows where he was then. Of course, I think I know where he was too. And that remains to be seen whether that gets proven or not. So there is a big hearing coming up August 18th where they're going to go over the motion to stay the case for this grand jury stuff so they can have more time to deal with that. The state's motion to try and not provide the family tree DNA stuff, which I think is a little bit of a red herring in every direction, but it could go either way on that one. And then this alibi thing. So there would be some movement on this case because right now, it's still scheduling for trial pretty quick. All right. Here's Sarah Boone. And I do see these Megan comments. I didn't expect that would be the case everybody's talking about, but I will try and get to those when we get to this, which is coming up soon. The Kohberger was more interesting to me, I have to say, as a lawyer, because, you read the headlines about things and then you read the actual filings and you see, okay, here's what's going on. Now, I don't hold it against the defense for filing these things, and they don't have a lot of merit with it. They're trying to push as hard as they can for their client, but I'm not going to swallow everything they say whole either, and nor would I do that with the state. If the DNA evidence, I think, is pretty solid in this case right now. Yeah, I know about secondary transfer. I've linked the study a couple of times about that issue, which is real, but the rarity sometimes of that with sole source DNA. Read it if you want. If you don't want to read the study, then you're free to imagine it however you want to be, and then that's okay too. All right. So Sarah Boone, is there a $400 an hour doctor in the house? The trial's delayed as the defense seeks a court order to pay another expert $400 an hour because the JAC in its response revealed that they'd already paid somebody over $7,000 to do a mental evaluation of her. I guess whatever that resulted in is not what she's wanting for her defense of battered spouse. So now they have this super expensive person that they want to hire, I guess, who would be willing to support this. And so that now they're going to have a hearing on that. So the trial is set nominally for October. But if you listen to that, you heard the judge and defense counsel agree we're just putting it on the docket for that. We all know this case isn't going to get tried in October. So some people are saying, oh, it's cases in October, and that's technically true on the docket. But I did hear the judge and defense counsel say it's not going to happen then. So it may not happen this year. I guess we'll have to see. All right. Let's see. Also checking comments while I'm looking here. All right. Yeah. All right. So we already said what they said about their own argument to throw out the grand jury based on the standard that's being employed. That would be a game changer for the justice system across the United States of America. Let her keep talking. Sarah did post her new letter. I read that when I got a break from the stream the other day. And while it's certainly bears indicia that she wrote it, given how it is written, she laments in it that no one is hearing her truth, yet nowhere in it does it tell what her truth of the incident is. So it's a great big secret, but the one person who in theory knows it is the one person who's not saying it, and yet she's mad at everybody for not knowing it. Does that make sense? Maybe that was an issue for the first expert who didn't charge $400 an hour. And I'm not slamming this person who wants to charge $400 an hour, but some people achieve greater clarity when they're paid well because they just have less stress in their life, right? So maybe that rate helps this person hone in on what it will be there in the facts to support Sarah Boone and her battered spouse defense, which I think is absolutely ridiculous, in my opinion, but I will not be an expert in that case on either side. All right, we watched this case. I streamed it when I could and listened to it when I couldn't, and it was quite fast for a murder case, a first-degree intentional homicide, and other nasty charges. So it was a quick guilty verdict, a quick finding that she did not establish her insanity defense. The burden was on her there. She had to get 10 out of 12 jurors. She got 0 out of 12 jurors because they were unanimous. And there were many phrases in it that I was sucking and cutting was one of the most vile, but there were a lot in this. I don't think it was the hardest case intellectually for a jury to consider guilt in, but it was terrible, I'm sure, to hear it and see the pictures of it. Now, the fact that it went to a phase 2 insanity and the jury came back pretty quick, and it makes sense to me, but the insanity defense is more confusing than the actual case in chief because the law uses the term insanity. The medical people don't. Then it uses mental disease and defect, and that's not exactly how they do it either. And then whether that, created this lack of ability to know right from wrong or compulsion or whatever. So it can be confusing to marry the medical technology to the legal technology and see how it operates, but that's the jury's job, and they did it. Yeah, there's a question here about it says a person has a right to, there's a Speedy Trial Act in Idaho and of course the Constitution and stuff. But right now the Kohberger case is on track for that. But plus his attorneys are asking for a stay of the proceedings or at least a potential increase in time for that as they try and fight this indictment. So they're the ones seeking a delay at this point. Then there are cases in Idaho where an indictment goes away and it comes back again and the court finds that there's good cause for that, and then they keep on with it. I mean, it's not like they're going to go, well, I guess we printed this on yellow paper instead of white, the indictment, so let's throw it out and let this, if he is the guy, this quadruple murderer, walk free forever. You saw the quote out of the Supreme Court case saying this is not really a game. So there are certain defects that can result in you just being let off, but think about it. That's not how it often happens. Or else, requiring absolute perfection in paperwork is itself not a fundamental right. And sometimes if he wants to attack the indictment and there's a technical defect to it, then I would think they would just either allow them to amend it or reissue it or whatever. They're not going to let him go free so he can start chopping people up again. Let's see. Taylor really is insane. Well, I think, I think I said in my stream during her case that I think she's crazy or insane. I have no problem with that because she's wired wrong, right? She's not faking that. Now, she may have been malingering for certain purposes, as some of the experts said, but she's bonkers. Now, whether that meets the legal definition of insanity, as I was saying in a minute again, that goes over to the medical realm, which I am not an expert in. And good to see you on the stream. And I was talking a little bit about some of these NC cases, including Wendell Williamson when he walked off the campus at Dorothea Dix and went swimming in Lake Wheeler, I think. So, all right. So the Taylor Schabusiness case was fast and furious, and it's over. And that is that on that one. So here's the case people have been talking about in the chat a little bit more than I thought we would see. And one more comment here before I take out of this, which is, see, the thing about medically insane, I don't think there is a medical term called you're insane. I think that's just what people say and what the law says. That's how I understand it. There's, medical diagnosis of she has this issue or that or whatever. And then you translate that into the legal term of insane, or I use the word insane all the time, but I don't think doctors do. But I'm not a doctor, but I think that's correct. And then the judge, if you remember, gave an instruction that, listen, you're free to ignore medical terms, jury, because we're trying to merge the law and the medical stuff here. So it doesn't exactly sync up. Somebody says, a body language expert said she was acting crazy, not actually crazy. Sometimes crazy people try to act even crazier. And that's the boat I would put her in. I do believe that she's, she meets my definition of crazy. That's not to say she meets the legal definition of not being responsible for her crime. All right. Let's see here. Yes, there's no legal or medical insanity, but we know it exists. Right. I mean, people could be insane, but I am saying when the experts get called to the stand, they don't go, she's insane. They use the medical terms that they're, yes, for me, the medical term is bonkers. That's my medical knowledge. If somebody is bonkers, that's the way that I would put it. And that is why I don't practice medicine, in addition to not being licensed, any form of medicine, holistic or whatever, beyond the application of a Band-Aid or the drinking of whiskey. So in Megan's case, she has spent about 500 days in jail. She was in pretrial detention for her case. And she was not charged with murder, okay? Because there is some concern about, how was she convicted? And I get that. She was convicted of using or releasing for an unlawful purpose a chemical irritant that resulted in death. That's it. And now that statute, though, in Michigan carries a potential of a significant sentence. I think maybe even up potentially to life. So that's what she was convicted of. That's really the elements to it. And the unlawful purpose can be harassing somebody or even causing a slight injury to them or something like that. So yeah, you pick up a bottle of thing that has skull and crossbones in it and says it's poison on it, which this did, and throw it on somebody because you're mad, you're probably violating the statute. Now, that doesn't mean you should get life in prison. I hear that. And she didn't. Here she got a 1-year sentence, so she's out for time served. I didn't read the judgment. I haven't seen that, but I saw a news report of it that says that she's subject to a mental health exam, an alcohol drug test, a 6-month review in court. She has to finish high school or GED. She has to be home at night by 9, and an electronic tether. I don't know how long those conditions last, but it looks like the judge put some significant conditions on it. I didn't really pay a lot of attention to what she was saying in court because, you're going to tell the judge what the judge wants to hear at that point, and it might be heartfelt and it might not be. I'm looking more to what she did in the general sense of all the witnesses testifying. I think her father would not, of course, have wanted her to go to prison for life. I really don't think so, because he tried to even protect her when he was in the hospital. And she did have tough circumstances and stuff like that. So here's one of those situations where I think the judge makes the decision, and the judge has a range of things the judge can do. And how can you call that wrong, right? How can you call it wrong? So I don't know. This was a terrible situation, and what she did was terrible. Did she want to kill him? I don't know. All I can say is I think she has her own personality issues based on how she responded to the injuries to her father. That's my opinion. And I hope that she gets some kind of counseling and therapy and is able to grow from this and become a better person. Because I think I didn't like her based on, and I know she's young, but I was young once too, believe it or not. And I can't imagine causing the death of my parent and just really, except for when I'm in court trying to convince people that I care about it. Otherwise, really not indicating that I care so much about it, and just definitely don't want to have to deal with it. But the judge listened to all this and made the decision, and that's what you got. And it doesn't outrage me one way or the other. Hopefully this never happens again, and she learns from it. The Crumbleys. So here's a little intersectional small world department. Ethan Crumbley is having his sentencing hearing. I think today it's continued and started yesterday, where he's trying to dodge being in prison for life because he was a minor at the time of the crime. So he gets a kind of a special hearing for that. His mother, who's in jail right now, awaiting trial for her potential responsibility for what he ended up doing in terms of what she did that enabled that, whether you agree with it or not. We'll hit that topic separately. My point here is he's doing this now. We'll see what the judge does with it. His mother helped Megan draft her statement to the court or gave her advice and coaching. And apparently they spend time talking to each other. And that's good because she knows about kids killing people. And maybe she was able to help there. I don't know if she's helping, and I guess not, her own son write his statement. So, all right. So, but of course, her mother, or his mother, Ethan's mother and father, are waiting charges on involuntary manslaughter. It's a big proximate cause issue there because the superseding cause of this guy intentionally going out shooting people normally would break the proximate cause chain. Did a long video on that, potentially boring, going over the case law and how the Court of Appeals reached its decision that in this case, we're going to let this trial proceed forward. And this is not precedent for other things. They even said that in their decision. So people are worried about it being precedent. It's not really because they said it's not. And courts can do that if they want to. Now, the Crumbleys have asked the Supreme Court to get involved and review the Court of Appeals decision. And I don't know whether they're going to do that or not at this stage because this is typically something that's litigated if there's a conviction. So the Supreme Court may wait or they may go ahead and do it. I'm not sure what's going to happen in that case. I could have seen the Court of Appeals say, while what they did was really bad, we find the superseding cause still breaks the proximate cause chain. I also can see their logic to say it isn't because they're saying the parents engaged in their own acts of gross negligence and it may not even be a proximate cause kind of issue anyway. And I can see that either way. What I cannot see is thinking that it was a good idea to place a firearm in the hands of a child who you knew was having mental problems and was seeing things and hearing things that weren't there and was having all these problems and asking for help, which he definitely was, according to his own reports to his friends and stuff. My parents won't help me. And the parents text between each other. So I got a lot of guns and I've had guns around kids and I've told a lot of kids to shoot guns. And I think you have a responsibility as an adult. And a lot of states have safe storage laws and things like that, where you could be convicted of a crime without this proximate cause issue coming into play. They don't in Michigan, so they don't have that available to them. And again, I can see this charge having been thrown out, but I also think they were highly irresponsible here to leave that firearm where this kid could have access to it. Sorry, I just think you have a while you have a Second Amendment right to firearms, you have a responsibility, and they didn't exercise it there. But I could see the other position on this too. So let's see what we got in comments here because we're to the end of the case updates. This has gone by for me pretty fast. Thanks for that. Yeah, the Megan case was really sad. She picked up this caustic solution that's used for cleaning out drains and threw it on her dad and threw water on him, and it burned him so much that he ended up dying. But of course, he didn't appear to react to that, and he was drunk at the time. And I think that was the nature of her home life. The place was disgusting. They used to argue and fight, I think, a lot. And the guy wouldn't call for help himself, but rather just kind of stay on the couch after he gets this on him. Probably tells how drunk he was. So it's just a bad case all around. Just a bad case all around. I think the judge is over Boone. Potentially, yeah. And we'll kind of know that if the judge goes, I'm not buying you another expert, right? If the judge turns down the next expert, because you know, expert shopping, like how many experts do you need to go through who say you're not a battered spouse till you finally ring up one who does? There's a limit to what they have to pay for that. And if that was the topic that the first expert addressed, I think she's behind the 8 ball to get another newer, more expensive expert to testify. I wonder who all of her supporters are, talking about Boone. She did say in her letter that she receives fan mail. I don't know how she identifies that. She addresses her letters to the entire planet, so there are billions of people who could possibly respond. As I say, including the Vietnamese guy working his rice paddy, according to her, knows more about her case than she does. That is what I know about her case. So I think we've hit all of the stuff for now. See what happens with Ethan Crumbley, and we got a little period of time here before the Kohberger hearings occur, and some of this stuff gets settled in that case. And well, that's it, I think. And I appreciate everybody coming in and chatting about this stuff, and have a good weekend. And that's it. Thanks. Bye.